Good evening. Thank you for coming out on this chilly evening. I'm Irma Russell, Dean of the University of Montana School of Law. I want to welcome you and thank you for attending tonight's installment of the President's Lecture Series. I want to thank President Engstrom for sponsoring this event, and I want to thank Professor Richard Drake for working to organize it. Tonight's lecture is entitled Keeping Faith with the Constitution. And our speaker is Professor Pamela Karlan, one of the nation's leading experts on voting and the political process. She is the Kenneth and Harl Montgomery Professor of Public Interest at the Stanford Law School. I have a little bit of background information. Professor Karlan received her Bachelor's of Arts from Yale University, her Master's from Yale's Graduate School of Arts and Sciences, and her JD from Yale Law School. Currently a Stanford professor, she is a member of the American Academy of Arts and Sciences and of the American Law Institute. At Stanford, she founded the Supreme Court Litigation Clinic, which allows students the opportunity for hands-on learning. I'm particularly grateful for her visit because hands-on learning is part of our DNA here at the University of Montana and part of our focus at the law school. After law school, Professor Karlan served as a law clerk for Justice Harry Blackmun of the U.S. Supreme Court. She is currently a member of the Board of Directors of the American Constitution Society. And tomorrow she will speak to our chapter here in Missoula of the American Constitution Society. Professor Karlan is an award-winning teacher and a productive scholar. She has authored over 48 scholarly articles and co-authored 3 books on constitutional law. Tonight's lecture bears the same title as one of her books, Keeping Faith with the Constitution. It articulates the vision of the Constitution and an approach to its interpretation that has enabled it to retain relevance for every generation of Americans while remaining faithful to the original document. This is a challenge, both relevant and faithful. But that's a challenge that must be fulfilled in order to have a durable Constitution. I've taken a little bit from her own words in that book as part of this introduction. And it's a bit of a leap. We sometimes use ellipses. I leap from page 20 to page 155. So I take a little bit of liberty, but I think it captures something that speaks to me. Overall, the Constitution, and this is the quote, overall, the Constitution is a profoundly visionary document. Just as the framers could not have imagined the internet, DNA, global warming, or women's equality, there are undoubtedly social developments and constitutional questions we cannot imagine today. But if our national experience is any guide, we can be confident that the Constitution's text and principles will endure. And they will endure because of their adaptability to new conditions and new challenges through an ongoing interpretation of that document. This quote reminds me of how much I admire this confidence. If Professor Karlan, who has been much closer to the constitutional process, can look with confidence, then that gives us all confidence of the ability of that document and the individuals who interpret that document to go forward and to also to endure and bring our principles forward. So with that, I would like to introduce Professor Carlin. After her comments, there will be some time for questions and answers. Professor Carlin.
Thanks so much. That was a lovely introduction, and thank you all so much for inviting me here to speak with you tonight. Since 1789, when our Constitution was initially drafted, other nations' constitutions have come and gone. By one recent estimate, national constitutions have a lifespan roughly the same as that of a Great Dane. They live about 17 years maximum. The United States Constitution, by contrast, has endured for hundreds of years, and not only endured, but actually thrived. Now, why is that? Well, I think the reason that the United States Constitution is the world's most enduring written constitution, the constitution that's endured longest in all of recorded human history, is not simply the genius of the 55 men who gathered in Philadelphia in 1789. Rather, it's the way that generation after generation of Americans has made the Constitution ours. The Constitution endures because its meaning and application have been shaped by an ongoing process of interpretation. And that process includes both judicial interpretation in cases before state and federal courts, and transformations in constitutional understanding pressed by political leaders and by ordinary citizens throughout our history. And I don't know how many of you watched on C-SPAN or one of the television stations recently when the House of Representatives began its session by having various representatives get up and read parts of the Constitution. I know a lot of people were really quite cynical about that and thought of it as a kind of partisan political ploy. And there was some of that in there. Particularly, for example, in the fact that they declined to read some parts of the Constitution that haven't survived and haven't survived for good reason. But I found the most moving part of that process to be when Representative John Lewis from Georgia got up to read the 13th Amendment. Because John Lewis, as a 25-year-old college student, was one of the leaders of the march over the Edmund Pettus Bridge in Selma, which was one of the high points of American history for ordinary citizens changing the meaning of the Constitution. And nothing that any member of Congress has done, I think, in our entire history, or perhaps even that any judge has done in our history, has done as much to bring the reality of the Constitution and its promise of equality into being as what John Lewis did on that bridge. So ordinary citizens make our Constitution great, as much as courts or lawyers. And our Constitution retains its vitality because it's proven adaptable to the changing conditions and the evolving norms of our society. Its words and its principles resonate centuries after they were written, because time and again, as Justice Oliver Wendell Holmes reminded us 90 years ago, we've interpreted the Constitution in light of what this country has become. Justice Holmes was right when he wrote that the words of the Constitution have called into life a being the development of which could not have been foreseen completely by the most gifted of its begetters. It was enough for them to realize or to hope that they had created an organism. It has taken a century, and now another century after that, and has cost their successors much sweat and blood to prove that they created a nation. Americans of all backgrounds can wholeheartedly take an oath to support and defend the Constitution when they're naturalized, when they join the armed forces, when they gain admission to the bar, or when they're sworn into elective office, not because of how our founding text was understood in 1789 or even in 1870, but because of how we understand it today. Now, in recent decades, this common sense understanding of the Constitution has been eclipsed by alternative conceptions of our founding document and the proper way to interpret it. Originalism, the idea that we can rely exclusively on what the public understood the words of the Constitution to mean in the years that they were drafted, has been vigorously championed by conservative justices such as Antonin Scalia and Clarence Thomas, and by judges like Robert Bork, and by prominent conservatives like former Attorney General Edwin Meese. In addition to and allied with that notion of originalism, what I sometimes refer to as the WWJMD question, or what would James Madison do, is the idea that we should have a strict construction of constitutional provisions. Now, tonight, I'm going to try to describe and defend an approach to constitutional interpretation that I think is richer than originalism or strict construction, that I think is more consistent with the history of our constitutional practice, and more persuasive in explaining why the Constitution remains authoritative over 200 years after the nation's founding. Interpreting the Constitution requires applying its broad principles to the conditions and the challenges faced by successive generations. The question that properly guides interpretation of the Constitution is not how the Constitution would have been interpreted at the time of the founding, but rather how it should be applied today in order to sustain its vitality in light of the changing needs, conditions, and understandings of our society. That's what I mean by keeping faith with the Constitution. To be faithful to the Constitution is to interpret its words and to apply its principles in ways that preserve the Constitution's meaning and its democratic legitimacy over time. Original understandings in this sense are an important source of constitutional meaning, but so too are the other sources that judges, elected officials, and everyday citizens regularly invoke. The purpose and the structure of the document, the lessons of precedent and our historical experience, and the practical consequences of legal rules. Now, in saying this, I want to begin by saying that constitutional interpretation has to be faithful to the character of the Constitution itself. It's a document, and it's a written document, but two features of the document I think are particularly important. The first of these, as the great Chief Justice John Marshall wrote in the early 19th century, is that the Constitution, and here I'll quote the Chief Justice, was intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. And so, it turns out it's a charter of general principles open to what he called fair and just interpretation over time. Second, and this is critical, the Constitution is a document designed to be understood by the public. To quote President Franklin Roosevelt, it's a layman's document and not a lawyer's contract. Throughout our history, the questions of the meaning of the text and principles of the Constitution have been the subject of public debate, and at times intense mobilization among the American people and their representatives. And so although I disagree with much of what the Tea Party stands for, I find it heartening that actually a large number of Americans are debating what the Constitution means, what the powers of the federal government ought to be, what the powers of state governments ought to be, and what powers are illegitimate for any government to exercise. Judges, of course, play a critical role in interpreting the Constitution, but the popular character of the Constitution, that the Constitution is a layman's document and not a lawyer's contract, means that constitutional interpretation is not exclusively the province of judges. Thus, I think it's neither surprising nor illegitimate that judicial doctrine often incorporates understandings of the document's text that have been forged by social movements or by legislation or by historical practices. Indeed, I think public engagement with the Constitution and with its meaning is what's enabled our founding document to retain its authority throughout changing times. But let me begin with some words about the origins of our Constitution that will show that a fuller understanding of our framers' intentions undercuts the kind of fundamentalist originalism that seems much in vogue today. As Dr. Martin Luther King Jr. observed in his I Have a Dream speech, when the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were signing a promissory note to which every American was to fall heir. Dr. King was right, I think, to link these two documents, the Declaration of Independence and the Constitution, because our Constitution was drafted and ratified against the backdrop of our recent war for independence from Great Britain. And the Declaration of Independence which has far more stirring language in it in many ways than our Constitution, expressed Americans' aspiration for the kind of government they would create on the North American continent. We hold these truths to be self-evident, that all men are created equal, that they're endowed by their Creator with certain unalienable rights, that among these rights are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. So the Declaration of Independence expresses a background understanding among the founding generation that equality, that liberty, and that opportunity, what they called the pursuit of happiness, were fundamental rights, that legitimate government depends on the consent of the governed, and that the power of government should be organized to enable it affirmatively to secure and effect the rights and liberties of the people. Now, the framers were a bold but pragmatic generation. They knew they were creating a nation that would change in important ways over time. Their very decision to ratify the proposed Constitution reflected their recognition that America was an expanding nation in which commerce and not merely its agrarian traditions would play an increasing role. Moreover, the structure of the Constitution reflected the framers' comfort with innovation, as well as their determination to ensure that the government would have sufficient power to deal with the nation's problems as they arose. The amendment process has served over time to enlarge our basic commitments to liberty, to equality, and to democracy. And thus our Constitution reflects, in a spare outline to which we've given effect, the moral trajectory of a nation that has continually been striving for greater justice. Now, as the country has matured, the broad principles that were articulated in the Constitution have naturally been the subject of ongoing debate. Each generation, I think, has sought to remain faithful to those constitutional commitments through a process of interpretation and enforcement, both by Congress and by the courts, which in turn has been informed by public deliberation and engagement. And I want to talk now about a recent case at the Supreme Court that I think illustrates the point that originalism or strict construction is not the way that any judge really interprets the Constitution, that the way the Constitution has been interpreted has always looked at multiple sources of meaning and has looked at contemporary understandings as well as those of the founding generation. And the case I want to talk about here is a case called Heller against United States, about which you may have heard quite a bit. Heller involved the Second Amendment to the Constitution, which says that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. The issue in Heller itself was whether the amendment barred the District of Columbia from enforcing a law that prohibited handgun possession. And this law prohibited virtually all possession of handguns in the District of Columbia. And Dick Anthony Heller brought a lawsuit saying that he should have the right to keep a loaded handgun in his home to protect him. So it was for self-protection in his home. Now, the Supreme Court decided in a bitterly divided decision, 5-4, in favor of Mr. Heller's right to keep and bear the handgun. But what's interesting, if you read the case, is to see how the justices on both sides of the divide used exactly the same methods to think about the issue. So what divided them was not that one side used a clear method and the other side was just imposing its personal preferences. Rather, it was how they understood basic principles and how they weighed pragmatic consequences. So both the 5 justices in the majority, who were led by Justice Scalia, and the 4 justices in the dissent devoted a great deal of attention to parsing that text. And I read you the entire Second Amendment. They spent a great deal of time looking at that. And both sides looked at dictionaries from the 18th century and the early 19th century to understand what these words meant. They both looked at works about grammar in the 17th and 18th and 19th centuries to understand whether the phrase at the beginning, a well-regulated militia being necessary to the security of a free state, was a limit on what kinds of arms could be borne and under what circumstances, or was simply an explanation for why the right to keep and bear arms was protected at all. Now, the majority read the words, "the right of the people," to refer to a right possessed by individuals acting on their own, akin to, for example, the right in the Fourth Amendment of the people to be secure in their homes, their papers, and their effects. And the majority read the phrase "keep and bear arms" to refer generally to the possession and use of weapons, including weapons that are used for hunting or self-defense. The dissenters, by contrast, read the words "the right of the people" to protect individuals engaged in collective action, that is, individuals participating in state militias. And so they read the words "the right of the people" not as being akin to the right of the people under the Fourth Amendment, but the right of the people under the First Amendment, which talks about the right of the people peaceably to assemble. And unless you're sort of schizophrenic, you don't assemble with yourself. You assemble with somebody else. And it construed the words about keeping and bearing arms as a reference to the military use of weapons and not to other sorts of uses of weapons. Now, each side also defended its reading by invoking historical evidence, including English antecedents stretching back to the early 17th century of the Second Amendment. They talked about the Second Amendment's drafting history. They talked about provisions in state constitutions that were drafted around the same time. They talked about commentary that occurred in the 18th and 19th centuries. And the majority cited this to show that there was an express understanding that people would keep and bear arms for self-defense. At the same time, the dissenters observed that the framers considered but then rejected language that would have talked about individual self-defense and civilian use of weapons. According to the dissenters, the drafting history showed that the Second Amendment was mostly designed to protect state militias from being taken over by the federal government. Both sides also grappled with precedent, especially a 1939 case called United States against Miller, in which a unanimous Supreme Court upheld a law that made it a crime to possess a sawed-off shotgun. And in that case, the Supreme Court has said the possession of a sawed-off shotgun is not protected by the Second Amendment in the absence of any evidence tending to show that its possession or use at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia. So what the dissenters said is that Miller turns on the basic distinction between weapons that can be used for military purposes and weapons that can't. And since a sawed-off shotgun, as I understand, is basically used to rob banks and wouldn't be a particularly effective military weapon, it's not the kind of weapon that's protected by the Second Amendment, because the Second Amendment only protects weapons that could be used for law-abiding purposes. The majority said, well, no, that's all that Miller was about. It was just saying that weapons that could only be used for illegal purposes aren't protected, but any weapon that's used for law-abiding purposes is. So they didn't differ in that they should look at precedent. They didn't differ in looking back to the generation of the framers. And they also didn't differ in the way that they both looked at modern-day considerations to set out what they thought the rule should be. So Justice Scalia normally says that the only way for a justice to interpret the Constitution is for him to ask how members of the founding generation would have understood the words. But his opinion for the Supreme Court in Heller, if you read it carefully, ultimately adopts an interpretation that depends on current social norms and conditions. And this is apparent when you look at how the court answered two fundamental questions. First, what kind of arms are protected by the amendment? And second, what constitutes a forbidden infringement of the right to bear arms? Because the amendment says the right to bear and keep and bear arms shall not be infringed. So as to the first question about what kinds of weapons are protected, Justice Scalia squarely rejected the idea that arms covered only the kinds of weapons that were covered in 1791 when the Second Amendment was ratified. Here's what he said about that argument. An argument said, well, you know, if you want to carry a flintlock pistol, make our day. If you want to carry a musket, you know, we're with you. And he said, no, people have the right to semi-automatic handguns, which of course is not a weapon known to our founders. And he said, some have made the argument, bordering on the frivolous, that only those arms in existence in the 18th century are protected by the Second Amendment. We do not interpret constitutional rights that way. Just as the First Amendment protects modern forms of communication, and here Justice Scalia cited a case that involved the protection of free speech on the internet, and the Fourth Amendment applies to modern forms of search, and here Justice Scalia pointed to a case that said that the police use of thermal imaging devices violated the Fourth Amendment. He said the Second Amendment extends prima facie, which just basically means on its face, to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. Now, why is that so? Well, it's because many words in the Constitution are properly read to stand for broad principles. Here, the right to use technology, or what Justice Scalia calls instruments for self-protection. And those broad principles' practical meaning depends on an interpretation that's responsive to evolving social conditions, including advances in technology. At the same time that Justice Scalia is recognizing that the semi-automatic pistol, semi-automatic handgun is protected, he also recognized that not all weapons were protected. As a historical matter, he said, the amendment accommodated the tradition of prohibiting the carrying of what were called dangerous and unusual weapons, and covered only what he called arms of the kind in common use at the time, since those were the kinds of guns that men who were called for militia service would have brought with them. So under that reading, he said, it's perfectly okay to deny people the right to carry sawed-off shotguns. But what distinguishes a handgun from a sawed-off shotgun? Nothing about the text of the Constitution, nothing about our history. Instead, the difference lies in contemporary social practice, or as Justice Scalia put it, the fact that handguns are the most popular weapon chosen by Americans for self-defense in the home. By limiting the Second Amendment's protection in this way, the court interpreted the constitutional principle to have what Justice Louis Brandeis once called the capacity of adaptation to a changing world. Indeed, just as the sawed-off shotgun is not what the American people have considered to be the quintessential defense weapon, the American people may someday reach the same conclusion about handguns, on the belief that their possession is more dangerous than promoting of self-defense. So evolving social norms can change the ambit of the Second Amendment's protection as interpreted by the court. And here I want to add one thing about social movements, which is, if you go back to 1986, when Chief Justice Warren Burger retired from the Supreme Court, he gave an interview to that great legal publication, Parade Magazine, which many of you have seen on Sundays. It's a sort of supplement to local newspapers. And he was asked about the right to bear handguns, and he said, oh, come on, nobody thinks that right is in the Constitution. Now, how is it that we got from 1986, when a conservative Chief Justice thought the right was not in the Constitution, to 2007, when the Supreme Court thinks it is? Well, a lot of that was a social movement. It was a gun rights movement that changed people's understandings of what it meant to talk about the Second Amendment. In the same way that we're seeing today, changes in understandings brought about by a gay rights movement that changes notions of what equality means. But even with respect to handguns, for example, the Supreme Court in Heller, and this turns to the point about infringement, indicated it was receptive to a broad range of government regulation of handguns, including what it called longstanding prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of arms. Now, the amendment itself doesn't tell you whether those are infringements on the right to keep and bear arms. So how do we get to saying these things aren't infringements? Well, the most plausible explanation, I think, for why these aren't infringements is that they seem like a really good idea. That is, the practical consequences are driving Justice Scalia here. As the framers understood, and as the court has recognized in many areas, no right has an absolute applicability regardless of how severely it clashes with other important values. Thus, attention to real-world consequences or to the reasonableness of legislative judgments concerning real-world consequences is an ordinary part of constitutional adjudication. And the court's readiness to uphold various firearms restrictions simply illustrates this point. Today, as throughout our history, Americans continue to face the task of applying our Constitution to new contexts. William Faulkner famously wrote that the past is never dead, it's not even past. And so we still face questions that our forebears faced. But we also face new ones. And as the Dean said in her introduction of me, the Constitution's texts and principles have to be adapted to respond to those changes in the world. Constitutional law has only begun to consider the array of issues arising from the omnipresence of computers. Earlier this month, the California Supreme Court, for example, held that the search incident to arrest doctrine, which is a doctrine that says if the police arrest you, they can search anything they find on your person, applies to allow the search of cell phones. Now, when that doctrine was first developed in the 1930s and 40s and 50s and 60s, there was a limit to how much information about yourself you really could carry. I mean, you might be carrying an address book with you, or your diary, but of course most people didn't carry their diaries or address books. You wouldn't be carrying your entire life with you. But as anyone who's lost a cell phone knows, sometimes your cell phone does contain your entire life. And if you can search somebody's cell phone, what about searching their laptop if you find that on them? Because that contains all of the data you've got. And if your laptop can connect from anywhere using a wireless card, then can they search anything about you that they could get from having physical possession of the laptop? State Supreme Courts have been grappling with this issue in cases over recent years, and they disagree about it. That's an issue that's going to have to be resolved. And it can't be resolved by saying, what would James Madison do with your computer? The Supreme Court had a case earlier this year, a case called Entertainment Merchants against Schwarzenegger, that involves California having a law that bans the sale of violent video games to people under the age of 18. And at the oral argument, the lawyer for the state was making the claim that violence is different from other kinds of activities, and therefore you can ban violence, you can ban children from gaining access to violent depictions in the same way that you can ban them from seeing dirty pictures, even pictures that adults would have the right to see. And Justice Scalia was trying to make the point that in our history, we've always treated obscenity differently than and pornography differently than we've treated violence. If you want to read about violent stuff, there's a lot of violent stuff you could read about just by opening the Bible. So it's not as if books that were available to children at the time of the framing didn't have depictions of violence in them. True, they weren't graphic in the way that they are today, but they were there. And so Justice Scalia was pressing the lawyer for the state of California about this. And Justice Alito chimed in with, what he's really asking you is, what would James Madison think of violent video games? And the answer to that is, well, Grand Theft Horse and Buggy doesn't have that kind of oomph to it, right? But Justice Scalia kind of waved him off and said, no, I'm talking about the broad principle of access to violence. So that's another one of these issues where we have to adapt the First Amendment to the changed conditions. What do we do about the fact that government can engage in electronic surveillance now at virtually no cost? There are cases now, but can the government slap something on your car that travels along with your car and gives them GPS information? What about the internet and campaign finance regulation? And if that technology is not enough, how should changes in scientific understanding inform constitutional law? The Constitution has long recognized principles of liberty and autonomy with respect to intimate matters of family life. How do those principles apply to questions about abortion or about end-of-life issues in light of medical advances and our evolving understandings of human development and cognition? What constraints does the Constitution impose on the government's collection and use of human DNA? What power does Congress have under the enforcement clauses of the Reconstruction Amendments to regulate states' use of genetic testing? And how, and especially in Montana, given what I understand is happening in your state legislature right now, how should the Constitution respond to changes in our understandings about the environment? The current Supreme Court is very divided over the scope of federal power to enact environmental protection statutes, with several of the justices inclined to distinguish between environmental regulations that affect interstate commerce or navigable waters and those that bear only on intrastate territory, wetlands that aren't connected to the larger aqua system or the like. But as our understandings of ecology deepen, that distinction may become untenable. More fundamentally, in a world of physical and economic global interdependence, how should legislatures or executive branch officials or the courts think about enumerated power and federalism? And these changes that have to inform how we think about what the Constitution means are not limited to scientific developments. As we've seen, changes in social understandings often and rightly change how constitutional principles are applied. Consider, for example, the history of litigation over the right to marry. State and local governments have always limited marriage to certain people under certain circumstances. Not until 1948, in a case called Perez against Sharp, did any court in the country hold that the Equal Protection Clause forbids states from refusing to recognize interracial marriages. And it took an additional generation after that, until 1967, before the United States Supreme Court reached the conclusion in Loving against Virginia, one of those Supreme Court cases where the name sort of tells you everything you need to know. In subsequent years, the Supreme Court came to recognize that the marriage rights of prisoners, and it came to recognize the marriage rights of indigent individuals. Today, there's a vigorous debate over the right of same-sex couples to marry. That debate would have been unthinkable a half-century ago, just as a debate over the right of interracial couples to marry would have seemed pointless a half-century before that. Here, as in other areas, constitutional understandings have changed as the norms and values of our society have changed. And as the dean said, and you always have to worry that some of your lines will get used in the introduction, but just as the framers couldn't have imagined the internet or DNA testing or global warming, and apparently here in Montana some people can't imagine global warming even today, but just as people couldn't have recognized that at the time of the framing, or women's equality, and here Justice Scalia gave an interview about a month and a half ago where he said the 14th Amendment, which has the Equal Protection Clause in it, has nothing to say about women's equality. If women want equality and they think the Constitution should give it to them, they need to go and get their own amendment. Right? That's the view, that's the kind of originalist view, and it's important to understand those consequences. But just as the framers couldn't have imagined all those things, and we can, there are social developments and constitutional questions we can't imagine today. Now, whatever allure there may be in theories that would reduce constitutional interpretation to a simpler, mechanical process, those theories ultimately fail to explain our actual constitutional practice and its remarkable achievements over time. The American people adopted the Constitution, as they said in the preamble, in order to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty. As our nation and the world continually change, constitutional interpretation that's faithful to those purposes enables and motivates each generation of Americans to keep faith with the Constitution. I'd be glad to take questions. So I think there are 2 microphones, right? So please just come up and ask questions. Yes, so we're going to share the mic and we're going to sing some barbershop quartet things for you. No,
right.
We could threaten to do that, but that's just to make people ask questions instead.
That's right. So maybe I'll recognize some people, and I'm supposed to take this, and we'll pass it back and forth, maybe have a repartee, and I promise not to steal any more of your quotes. So it's now your turn. We have 2 microphones set up, and this is being recorded. So if those of you who would like to ask a question could come to the microphones, we would appreciate it.
Or we could do this like law school and I would just cold call.
Good.
Yeah, I had a question because you said early on places in the Constitution where there's been a failure, but I wasn't sure what those would be when you said they left those out of the readings.
Sure. So the most notable example of the failure are two clauses that were in the original Constitution, which, if you read the original Constitution, it doesn't mention slavery, but there are two clauses in the Constitution that dealt with slavery. One of them is known as the 3/5 clause. And the way that clause worked was it said that in trying to decide how many Congress people each state would get, you counted up the number of people, but the way you counted was you counted the whole number of free persons. You excluded Indians not taxed, which essentially meant Indians on tribal lands, and then you counted 3/5 of all other persons, which meant that slaves in the South, who were basically property, were counted as 3/5 of a person. They did not read that. And there was an additional provision in the Constitution. The Constitution generally says you can amend the whole document, and it provides a way of amending it. But there are two pieces of the Constitution that can't be amended. One of which in Montana you actually benefit from, the other of which has disappeared. The one that you benefit from is the equal suffrage in the Senate, which is every state, no matter how few people live there, gets 2 senators, and you can't take away those 2 senators, and you can't amend the Constitution to take away those 2 senators. The other provision was one that said that Congress could not pass any law respecting, and here I think the actual language is the importation of persons, prior to 1808. And this was a law that basically said, this was a piece of the Constitution that said, you can't stop the slave trade until after 1808. And so those two pieces of the Constitution, like no representative wants to get up and read those, because you can just imagine the YouTube clip of one of them getting up there and saying 3/5 of a person. And so those are what I mean by there were some failures in the original Constitution, and they were baked into the document. Slavery was baked into the document in its original form, and there was a lot of compromising that went on in order to get the Constitution through that recognized slaveholders' rights in various ways. And so that's what I was referring to.
So we'll take over here at this mic.
You've been speaking, you've been limiting your thoughts to the U.S. Constitution, a written document. Have you had any thoughts that you could share about those societies that don't have written constitutions but have a firm sense of a constitution, please? Particularly, do any of these issues that you've been discussing, originalism, apply in those societies?
Well, there are some countries that don't have written constitutions. The one that would be most familiar to folks here is the United Kingdom. Doesn't have a written constitution. The British Constitution has always been a sort of organic understanding. Their system is also, though, a system of parliamentary supremacy, and until the kind of rise of the European Union, which now has the European Court of Human Rights, which has sometimes told Great Britain it can't do some things it wants to do. But before that, they didn't have any written document. They had parliamentary supremacy, and so the constraint that the Constitution exercised was a constraint that came from a shared understanding. I think the reason we started with a written Constitution is that we were starting a new nation from scratch, and we sort of recognized it was a new nation. And so how would you know to have a president if there weren't a constitution or the like? Almost all modern emerging democracies have constitutions. One of the big differences between their constitution and ours, I'll just say something about two of the differences that you see. One of the differences that you see a lot is they have a much more specific set of enumeration of rights than we do. Modern constitutions tend to be much longer in general than ours, and they often have what are called affirmative rights in them, like a right to health care or a right to education or the like, which although many state constitutions have a right to education, federal constitution doesn't. The other thing is a lot of those constitutions have emergency powers provisions in them. That if there's a national emergency, there are additional powers that the government gets. And our Constitution doesn't, except for one very narrow exception, which is that Congress can suspend habeas corpus during times of invasion. But today, I think it's fair to say that every emerging country wants a written constitution. And so you don't see new societies that don't have them. You do see, as I say, some older societies that just never got around to feeling the need to write one. The Canadians, for example, didn't actually write their Charter of Liberties and the like until sometime, I think, late 80s or early 90s. And before that, they just had an organic understanding of what was in bounds and out of bounds, a kind of shared vision. The more heterogeneous your country is, the less likely it is that you can just kind of rely on a shared traditional vision to get you where you want to go.
Thank you. I think that brings us over to this mic.
Yeah, thank you for taking the question. You kind of, I just want to say before I even start that what you're doing, I think, addresses what I'm about to ask about, but it regards sort of questions of education, civics education, and then also, you know, general public discourse. I was on the SCOTUS blog this morning looking at the Citizens United versus FEC, and I started to get into sort of all the arcane appellate briefs, and I started to realize, like, I'm way over my head on this. And I've read, you know, things like Lawrence Lessig and Boston Review talking about it, and you know, you can get sometimes I think a taste or a sense of what's going on, but oftentimes I think it, in our national discourse, these big time rulings, these big issue rulings that will have a big effect on our nation, are oftentimes they go over the heads of most people. And you had said yourself, you know, you made this allusion to the layman's document. So I guess my question is, how do we sort of improve public discourse and improve civics education so that a ruling like Citizens United could be something that, you know, your everyday citizen can enter into debate about and feel like they're actually getting at the heart of the matter? Thank you.
Before I turn over the microphone, I've been standing here wondering why we have this set up this way, where I say, invite a question and then turn over the microphone. And I'm thinking now, maybe this whole setup was so I could invite you to come by and see the law school, because it seems to me that you might be a prime candidate. I don't mean to dismiss your question, because it's a good one, but I'm impressed with it and think that it's nice to note that Montana has a law school, just one, that's all it needs, and it's right here. But I take your question on public discourse and pass it now to our speaker.
That's a terrific question, and part of it is that over time the Supreme Court has become less interested, I think, in speaking directly to the American people. So if you were to go back and read the Supreme Court's decision in Brown against Board of Education, which was the case where the Supreme Court held that racial segregation of public schools violates the Equal Protection Clause, you would be able to read and understand exactly what the court was talking about there. They were talking to you directly. What an opinion like Citizens United is about, and for those of you who didn't follow the case, it was a case decided by the Supreme Court in about a year and a half ago. And in Citizens United, the Supreme Court struck down, declared unconstitutional some provisions of the Bipartisan Campaign Reform Act, the so-called McCain-Feingold Act, that dealt with the ability of corporations to spend money from their general treasuries on advocacy in elections. And what the Supreme Court held there was that the First Amendment, which protects freedom of speech whether the speech is engaged in by a natural person, that would be like one of us talking to you, or by what's called a juridical person. And corporations have been treated since the 19th century as juridical people. Now, some people think off the bat, well, this entire decision is an outrage because how can corporations be people and how can they speak? I don't actually think that's the problem so much with the decision, because I think there are many times that people organize in the corporate form to pursue an ideological goal. So, for example, the Sierra Club is a corporation. The ACLU is a corporation. The National Right to Life organizations are corporations, and they're designed to get up there and speak about public issues and try and influence how people would spend elections. The problem is that those kinds of corporations, we don't have to worry too much that people are spending money that goes to them that has nothing to do with the merits of their idea, because if you give money to the Sierra Club, it's because you agree with what they do. If you give money to a pro-life organization, it's because you agree with what they do. But when you buy something, when you go to Chick-fil-A, I don't even know, are the Chick-fil-A's up here? It's a southern fried chicken. It's sort of like a southern KFC-ish sort of thing. But Chick-fil-A, for example, is chicken with an attitude. And the attitude behind it, the people who own Chick-fil-A, is they are very conservative and very religious, and they want to spend their money to try and elect conservative religious politicians. Well, the average person who's trying to decide, like, what chicken restaurant do I go to, isn't aware of that, and it'd be hard for them to spend the amount of time to figure out, do I really want to buy Domino's Pizza if it means that Tom Monahan is going to do the things Tom Monahan does? Do I really want to buy, an Apple computer if Steve Jobs is spending the money on these things? So there, there's more of an argument for why those corporations maybe should be more regulated, and the Supreme Court just brushed that all aside. Now the problem is the Supreme Court, in the opinion, this is the area I teach in. The opinions were hundreds of pages long. There were, a bunch of different opinions in the case. They talk in very technical language. So to some extent, those opinions have to be distilled and summarized for you by people with some legal sophistication, because they're just some opinions that are going to be like that. The real hard thing is we don't train people in school when they're in elementary school and high school, which is where civics education really has to take place. We don't train them to think critically anymore. We're so worried about math scores and reading scores that we don't think about critical thinking as one of the things that people have to be taught if they're going to be effective citizens. Because if you were given that kind of training, you could read, even if you couldn't read the Supreme Court opinions itself, you could read relatively sophisticated commentary and make up your own mind. And that's what I think we're sort of lacking now. And one of the reasons that Chris Schrader, who's now the Assistant Attorney General in charge of the Office of Legal Policy at the Justice Department, and Goodwin Liu, who's a professor at Berkeley, and I, one of the reasons we wrote the book is we think it's an accessible explanation of a lot of these big areas. And just as a sort of statement against interest here, you can download the whole book for free. From the internet in PDF form and read it for free if you just go to acslaw.org and look for Keeping Faith, and it'll just give you instructions, and you can read it. And it will explain to you, for example, how we're thinking, what the Commerce Clause is about, which is where our healthcare debate is right now, or what the Equal Protection Clause means with respect to equality and the like. But for far too long, lawyers have viewed this as a kind of like esoteric little guild thing where we all talk to each other in shorthand, and we don't talk to citizens more generally.
And if I might, we could enter a little dialogue at this point on Citizens United, because the point that you raise is larger than Citizens United, relating to the conversation of the Supreme Court with the people of the United States. But I'd like to focus just a little bit, because it's tempting, on Citizens United itself. Professor Carlin mentions that we are people, we're all people in a sense, and for some senses. Sometimes I might worry that we're the subcategory, humanoids, and the occupation of the people category can be, after Citizens United, the big people category. So it makes me wonder about that continuum of rights that we extend to people. I don't think every developed nation extends the right to the attorney-client privilege, for example, to corporations. So if we give one more, and that would be the right against self-incrimination on that continuum, I wonder if we haven't created a problem, because of the structure of corporations themselves allows sequestration of information and of knowledge, even guilty knowledge.
Well, the corporation doesn't have
Yeah.
now.
Oh, I know it doesn't now. I'm just saying that in the march of recognition, whether or not this might, and it is a parade of horribles, of course, just one of the potential horribles, but it makes me wonder about that contest between individuals and the other kind of person that seems to have a lot of rights. So I would open that up a bit.
Yeah, so there's actually a case up at the Supreme Court this year, not about the right of corporations to avoid self-incrimination under the Constitution, but about whether corporations can be embarrassed. And the way the case got to the Supreme Court is there's an exception in the Federal Freedom of Information Act that says the federal government should not disclose information that normally they would have to disclose if it might embarrass a person. And this case involves a corporation that says, you've got our data, which under the Freedom of Information Act, you're getting prepared to release to the public, and that would embarrass us. Dahlia Lithwick, who writes a legal affairs column for Slate, I think almost everybody I know who's read her column on this particular case thinks it's the single best piece of legal writing they've read in years, because she writes about what happened at the oral argument on this as if the corporation had come into the court, and by ridiculing the idea that the corporation looked down, it blushed, it seemed embarrassed, it looked for its legs and realized it had no legs to stand on. I mean, it's a brilliant piece of legal writing that gets across this idea that corporations are not people in the same way that we're people. That is, even if same-sex couples get the right to marry, we're not going to allow people to marry a corporation anytime soon. Why is that? Because they're not the kind of person that has that set of rights. So I think it's a kind of difficult balancing test. That is, I don't think there's anybody who says corporations should have no rights at all, because so much of our lives is tied up in how corporations operate. If you really said corporations are not people at all, then the Due Process Clause wouldn't apply to them, and the government could just come in and seize all of a corporation's assets anytime it wants, because, after all, you're not taking property of a person. And the way that we protect against that kind of taking is that the Due Process Clause says you can't deprive a person of property without due process. So it's not an all or nothing thing. I think it's a very delicate balance. And to my mind, the current Supreme Court is far too pro-corporation and big business relative to some of its predecessors. But I wouldn't say that what we really want to do is abandon the idea of constitutional protection of activities that occur in a corporate form.
Well, and I think that's a very good example of the fact that very few things are yes, no, or flip a switch in the law. It is so much a balancing. And we're ready, sir, for your next question.
Thank you. The Obama administration announced yesterday that it would not be defending the Defense of Marriage Act. That was a reminder that state and federal executive branch officials are often reluctant to take on questions of constitutionality of statutes. For example, the Montana Attorney General has had a policy of not issuing formal legal opinions regarding the constitutionality of statutes. We obviously wouldn't want rampant, arbitrary disregard of statutes beyond what we already have by executive branch officials, but I'm wondering whether you could comment on whether there should be a more affirmative role for executives and attorneys general and so forth in confronting unconstitutional statutes.
Yeah, so just for those of you who didn't follow what happened yesterday, Attorney General Eric Holder sent a letter to the Speaker of the House of Representatives, which he was required to do under a federal statute that says if for any reason the executive branch decides not to defend the constitutionality of a congressional statute, they have to notify Congress about it so that Congress can think about what it wants to do. And what the Attorney General actually did was to say that the Department of Justice was no longer going to defend the Defense of Marriage Act as constitutional under something called heightened scrutiny. That the President and the Attorney General had determined that the way that the equal protection principle in the Fifth Amendment, which binds the federal government, needed to be applied to discrimination on the basis of sexual orientation, was that the government could only discriminate on the basis of sexual orientation if there was a substantial relationship between that discrimination and some very important government purpose. And here, they didn't see one to the federal government's refusal to recognize marriages that were valid in the state where they'd been entered into. So the important thing to understand about this case is that it only involves the question whether people who are married as a matter of state law, so for example, couples who got married in Iowa or Connecticut or Massachusetts, or whose marriages are treated as valid by the state they're in, as for example is true in New York, which will treat Connecticut marriages as valid, whether those people are entitled to have the federal government treat their marriages as valid as well. The Attorney General is not, the President is not refusing to enforce the Defense of Marriage Act. He's going to continue to enforce it until a federal court tells him not to. What he's simply doing is saying that he will not argue that the statute's constitutional. He will leave that to the courts to decide, and he will argue that they should decide that the statute isn't. So it's not a case where the president has decided to disobey the statute. So the federal government is going to continue to deny same-sex married couples from Connecticut or the couples who got married in California during the gap period, or it's going to continue to deny them the right to file joint tax returns and the like, unless and until a federal court decides otherwise. But the federal government is going to urge the federal court to decide otherwise. Here's the thing, the Constitution, here's a nice textual point about the Constitution. The Constitution requires that every state executive branch official, every federal executive branch official, every legislator take an oath to support the Constitution. And that's a non-delegable duty. You can't simply say, well, it's not my job to figure out if what I'm doing is constitutional or not. That's an obligation that falls on every government official, and for far too long, not just in the way that you were talking about, but in other ways as well, a lot of governmental officials have viewed it as it's the court's job to take all the heat for doing the right thing under the Constitution. So, for example, you'll often see legislators voting for bills they know are unconstitutional. South Dakota, for example, regularly passes abortion bills that they know are unconstitutional. They know that they're going to be struck down. In California, we had a wave of anti-immigrant legislation and an anti-immigrant initiative, Prop 187, that was clearly unconstitutional. And the governor who was supporting it at the time went around saying, you know, I just think it's good to send a message. You know, and the message is the courts are going to have to clean this up. And I think that's a disgrace, because I think the Constitution is something that every official is supposed to think about. So, you know, should they be issuing opinions? States differ dramatically on this. So there are a lot of states where there's something called an opinion of the Attorney General, and the legislature can ask for one or the like. In the federal government, there's something called the Office of Legal Counsel at the Department of Justice, which the president can ask for legal opinions and legal advice. The notorious torture memos that all of you have heard about probably, those were opinions from the Office of Legal Counsel on what did torture mean, and was the president bound by a federal statute that prohibited torture, or does he have the inherent right to override that statute? So there are mechanisms for that. I can't really answer why in Montana you don't have those mechanisms and whether it would be a good thing for you to have them or not, but lots of states do have them, precisely so that people can figure out, without there having to be litigation, what the Constitution obliges the executive branch to do or not to do.
Thank you, and I want to admire the questioner here, because when I read the New York Times yesterday, the alert that came across, my first reaction was, oh my gosh, they're not going to enforce. But you framed the question very carefully, that they would no longer defend the Defense of Marriage Act. So that framed it very well for us. Well, I was about to say we have time for only one more question, and I think we have one.
Thank you for taking questions. My question, I have a comment and a question that has to do with the gun rights, and I appreciate your comments around the gun rights. I'm a former U.S. Marine. I did 2 tours in Iraq. I'm pretty comfortable with weapons here in Montana. We also like our weapons. The comment is that we actually use shot-off shotguns and pistol grip shotguns in Iraq with our military. Not that I think that civilians need to be carrying these weapons or anything. And then my question is, there's a bill in front of the Montana legislation that would allow people who have concealed weapons permits that have gone through the background and that kind of thing to carry weapons into public buildings, places that sell alcohol, you know, these, you know, which I also agree is a bad idea. But the counter argument to that is that these people are not who we have to worry about carrying weapons. It's, you know, the people that commit crimes with weapons typically do not have the permit and so on. I was just hoping you could comment or speak something to that.
Yeah, and this is one I failed to mention. I tried to give an update on some of the issues alive in the Montana area right now, but I failed to mention this one, but it is a big issue.
Yeah, so one thing is, you know, and I think it's hard to to overestimate the difference between being in a place like Montana and being in a place like the District of Columbia. And part of the argument that Justice Breyer made in his dissent was, even at the time of the framing, Boston had regulations on carrying ammunition around and live weaponry, because the idea is when people are packed into relatively tight spaces, situations are different. And so one of the questions is, should the federal Constitution, through the Second Amendment, require a uniform treatment of guns throughout the United States? Or is this one of those issues on which reasonable states could disagree and ought to be allowed to make decisions for themselves? So that's the first kind of question. Second one, just which is a little bit in response to your point about the weapons that military forces carry, is even Justice Scalia would say, you do not have a right, for example, to a mortar in your house. Now, why is that? Because it's a very bad idea to have, and it's not the kind of thing that people generally carry. And so the divergence between military weapons and civilian weapons since the time of the framing to now is really quite huge, which is, at the time of the framing, the other idea was if you had a militia, they could protect you against a tyrannical federal government. And today, there are no weapons that the Second Amendment would protect you if the federal government decided to bring all of its force down on you. Because the weaponry is just different. And so trying to translate what the understanding was in 1789 to now is a complicated one. The last one is about these concealed carry laws and the like. And here the worries are not just that you carrying a gun for which you have a permit are going to go into a bar, get drunk, and then blow somebody's head off. I mean, although there is a worry about people with alcohol, regardless of whatever else they have. It's also the worry that you get into a fight with somebody and he grabs your gun and shoots you. So you don't have to be the criminal. My colleague John Donahue, who is an empirical law and economics professor at Stanford and one of the leading empirical law and economics people in the country, has been spending a lot of time to show that the studies that claim that the carrying of concealed weapons reduces the crime rate are inaccurate. And they don't take into account all of the factors that need to be taken into account. When you take those into account, it turns out that concealed weapons laws don't actually diminish the crime rate overall. And in part that's because a lot of the guns that are bought by people with concealed carry permits end up getting sold in the market to people who don't have them. And some of it is about that kind of control as well. Last thing I'll say about weapons is it seems to me that the question of the constitutional right to carry guns is as much about things that have nothing to do with carrying guns as it is about the actual carrying of weapons. And it has to do with people's sense of security more generally. It has a lot to do with people's sense of the federal government versus state and local governments. And so it's a very complicated issue. My point in using it as an illustration with you is to show that the arguments are not determined by constitutional method. They're determined by your sense of how to trade off complicated values against each other. And that's not something that asking how would James Madison have traded off these values against each other is going to get you very far in answering.
Thank you. Thank you all for your questions. And you'll have one more chance to applaud. I want to invite you all to join us out in the lobby where Professor Carlin is willing to do a book signing. And I'd just like to observe that I want to thank Professor Carlin for bringing these ideas and noting that keeping faith with the Constitution is more than about judges, of course. This is part of it, with Professor Carlin coming and talking with us, because we are part of that dialogue with the judges of our changing social commitment to pursuing justice and liberty. So please join me once again in thanking Professor Carlin.